Hello, my name is Russell J. Fishkind, and I'm a partner with the law firm Sol Ewan. Our firm currently has over 250 lawyers in 5 Mid-Atlantic states. I'm a member of the Personal Wealth, Estate and Trust Department in New Jersey and New York. In addition to estate and business succession planning, our department represents beneficiaries, executors, and trustees involved in contested estates. One contested estate issue we are seeing with increasing frequency is when individual accounts are retitled into joint accounts shortly before death, thus altering the intent of a written last will and testament. In the following example, Jane and Brad are siblings dealing with a typical manifestation of the joint account problem.
Brad, I'm really worried.
Why? What's up, sis?
When's the last time you talked to Rhonda?
You know, since Dad passed away, I haven't. I've called her and she hasn't gotten back to me at all. Why? What's going on?
She was acting really weird when Dad was sick. She was very controlling. She controlled what he ate, when he ate, what meds he took, when he took them, who he talked to.
Totally. She was a different woman than when Dad had married her. Absolutely.
Well, it's kind of starting to make sense now. I got something in the mail the other day from her attorney, and it says we're not getting any of the estate.
That's not right. That's not what the will says. I read the will. It says we get half of everything. Half of the stocks, half of the bank accounts, half the bonds, half of everything.
I don't know. This thing says that she went to the bank and she put everything in her name. So now it's joint ownership for everything. We're not going to end up with anything of Dad's.
Joint ownership?
Yeah.
That's not what Dad wanted. That's not right. We got to contact a lawyer. That's not right.
Can Brad and Jane seek legal action against Rhonda in order to gain possession of their half of their father's estate? The assets of the joint account will pass to Rhonda, so long as Dad intended to give her the assets. However, Brad and Jane might have a successful case if the transfer of their father's assets to Rhonda was made as a result of undue influence, exerted at a time of weakened mental or physical condition for the purpose of convenience, or as a result of fraud, misrepresentation, or mistake. Although the law varies by jurisdiction, the majority of cases on this subject center around the claim of undue influence. Undue influence exists where an individual is mentally, morally, or physically coerced into doing something contrary to his own volition. At least one court has ruled, in the case of joint accounts, the presumption of undue influence is raised more easily than in cases involving altered wills, so long as a confidential relationship exists between the holders of the joint accounts. A confidential relationship exists when, on one side, there's a dominant and controlling position, and on the other side, there's weakness, dependence, and trust. In our example, Dad and Rhonda have a confidential relationship if Dad places his trust in Rhonda because he's weak, dependent, or otherwise reliant on her. If a confidential relationship does exist, the surviving account holder bears the burden of proof and must show that a gift was indeed intended by the deceased account holder. In other words, Rhonda must prove that Dad intended to give her the assets instead of passing them through his will to Brad and Jane. If Rhonda cannot prove that point, the transfer will be set aside. This presumption becomes very useful in negotiating a settlement and oftentimes is a deciding factor in such cases. Typically, absent undue influence, courts will respect transfers between a husband and wife unless it can be shown that the accounts were titled jointly for convenience purposes only. In other words, if Dad and Rhonda set up joint accounts just so Rhonda could pay Dad's bills and manage his finances, then Rhonda is not entitled to Dad's assets. Instead, the assets will go to Jane and Brad according to the terms of Dad's will. Finally, Jane and Brad can prevent Rhonda from claiming the jointly held assets if the creation of the joint account was as a result of fraud, misrepresentation, or mistake. Since the litigation process takes time and can be expensive, Every estate must be carefully reviewed with an experienced litigator before filing for judicial intervention. If you feel that you've been unfairly denied an inheritance due to this joint account issue, you should seek a competent attorney to guide you through the legal process.